section of our legal issues for music teachers presentation will focus on copyright. I'm sure that if you're like me, every time you head for that Xerox machine, you have this nagging twinge of guilt and fear that you might be breaking the law. In many cases, we are breaking the law. Our copyright laws state that we cannot make Xerox copies of our printed music or videos or recordings. Copyright law also says we can't arrange copyrighted compositions. The actual copyright laws also prohibit us from distributing recordings of any copyrighted works. Technically speaking, copyright law even prevents us from performing copyrighted music in public. The law also prevents us from distributing any copyrighted work by means of digital transmission, including the radio, television, or the internet. Copyright laws are designed to protect composers and publishers so that they can make a living. The laws are balanced, however, with the pedagogical needs of music teachers to have reasonable access to copyrighted material for educational use. In order to balance the needs of music teachers against those of composers and publishers, the publishing industry and Congress have come up with what they call fair use for copyrighted materials by music teachers. If they hadn't done this, there probably wouldn't be any school music, and they probably wouldn't be in business. Basically, fair use is an exception to the law specifically for educators. It does not mean that music educators are exempt from following copyright laws. A fair use exception depends upon the purpose and character of the use of the copyrighted material. I think one of the overriding issues is whether or not it was used for profit or just for education. The other issue that the court would look at if there was a problem would be the nature of the work that was performed and stolen. Another critical factor in whether or not something's fair use is how much of it was used. How much of it did you copy? How much of it did you record? The court would also consider the impact on the market that occurred because you copied some copyrighted work. So what does this mean in reality for music teachers? It means that if that drummer loses that part just before your concert, you can go make a copy. You could copy maybe 1 or 2 pages of a large score and hand it out to the class. You can make a single recording of any of your performances. They've also given you permission to make recordings of exercises or tests that use copyrighted material. If someone spills a drink on your flute part, you can make copies. Teachers can also copy certain items for preparation or for use when they're teaching. With that said, let's take a look at some specific issues that might get you into trouble. The first common issue is that of recordings. We want to make recordings of our performances. Making a single recording is not a problem under fair use. What is a problem, however, is getting copies of recordings to students or parents, or sharing recordings on the internet for the No matter how proud you are of your group, it is illegal for you to post your concerts or recordings on the internet or to make copies of them with video or DVD or CD and distribute those recordings. Unless you purchase a license to do so. And it is not that difficult to get a license. You simply contact the Harry Fox Agency, fill out some forms, and send them a check. If you're making less than 250 copies or so, the costs are not that high. It's better to play it safe and get a license. The next issue we need to tackle is that of making your own arrangements of other copyrighted works. The publishers have generously given teachers the opportunity to edit or simplify, in other words, rearrange copyrighted music as long as the fundamental character of the work is not distorted. In 31 years, this issue is the only one I've ever heard of being prosecuted. A couple of years ago, a marching band festival was held in Phoenix, Arizona. During that festival, one high school band performed an original arrangement of Johann de Mai's Lord of the Rings, which is a very popular high school band selection. The festival was videotaped, and videotapes were sold on the internet. The publisher for Johann de Mai found out about this and sued the Arizona Music Educators Association, the high school, the school board, and the music teacher. If you're going to use an arrangement, make sure that you haven't distorted its character in any way that might be questionable by the composer. If your performances are going to be sold, get a license from Harry Fox. As I mentioned earlier, it is technically illegal to provide performances of copyrighted music. But fair use provides us with an exemption for school-related performances. They even let you sell tickets as long as the money from those tickets goes for educational use. You are not, however, allowed to broadcast a performance without getting a license, permission from the composer or his or her agent, which in the United States is the Harry Fox Agency. Let's take a look at some practical questions and answers that arise related to copyright. If you are using an accompanist, buy 2 copies. If you are performing for judges, get multiple copies of the original to give to the judges. I'm going to share one other example about this. A couple of years ago at the Hawaii Concert Band Festival, we'd hired several mainland judges to come in. Several of the performing groups handed the judge Xeroxed copies of his own works. That's right. The judge was a famous composer, and he was not at all pleased. Although it didn't result in a lawsuit, it did result in a very strong letter from an attorney and a very upset judge. Remember the earlier standard I mentioned about whether or not you are breaking copyright to avoid purchase. One of the interesting fair use exceptions occurs for distance learning educators like myself. If the site, the website where you are posting some material that's copyrighted, is secure and password only, and the materials you use constitute what you would normally be able to provide in a face-to-face classroom, you are given fair use permission. Posting your student performance videos on YouTube or Google Video is not legal. The Internet is a public broadcast medium, and the courts are treating it as such. There have been several recent legal cases regarding YouTube and other video providers. I envision a stronger crackdown on this in the future as the Internet becomes even more widely used. Take the time to go to the Harry Fox website and get a license so that you can make videos and DVDs, CDs, whatever you want of your concerts and sell them. Many people may have the misconception that the Internet is public domain. It is not. Everything you see on the Internet is copyright protected. I have never met a music educator who hadn't broken copyright laws at one time or another simply because publishers do not provide enough parts. This is especially troublesome for instrumental ensemble directors. What's a teacher supposed to do? Well, good question. I do not have an answer. I, too, have sometimes had to break the law on this. I think what we need to do is continue to lobby publishers to make their system of parts distribution much more flexible and customizable for those of us that do not have perfect ensemble instrumentation. While I have not heard of many cases where publishers and composers have gone after music teachers in lawsuits, the risks are huge. The bottom line here is play it safe. Get permission whenever you can.